By the end of this video, you will know exactly which seed instrument, the SAFE or the convertible note, is right for your specific growth stage. More importantly, you'll know how to model your dilution so you don't wake up after your Series A wondering where 40% of your company went. My name is Maritza Shay Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that legal stuff, like the securities regulations we'll be talking about today, might come back to bite them. Today, we're moving past the legal theory of the regulations and getting into the technical how of seed stage debt and equity linked instruments. We're covering these instruments for two reasons. One, they're absolutely essential for bridging the gap between your initial MVP or minimum viable product and a priced Series A round. And two, even if you're not a tech startup, these instruments are significantly less complex than everything that goes into equity investments like preferred stock. Both the SAFE and the convertible note postpone the very complex task of formally valuing your company until a later date. And if we can put off complex tasks, then we can save on legal fees. Now, the first step is trying to identify your maturity tolerance. The core difference between these two instruments comes down to their legal status. A convertible note is, at its core, a debt instrument, it's a loan. Early seed investors like convertible notes because, as the name implies, they can be converted into equity in the company if the startup grows more successful. In other words, if a potential investor is interested in a convertible note in your early stage startup or small business, their goal isn't really to get repaid on the loan. Their goal is to see you grow the business to either attract larger investors or a larger purchaser who will come in and buy the company. At that time, that's going to trigger the conversion. So, what are these events that will cause this conversion? Well, one of the most common is a next equity financing. So, if and when your company issues a certain amount of equity to future, usually larger, often venture capital investors, then these early seed investors will convert their principal and interest into equity for less than the price being paid by the later investors. More about that in a moment. Another type of conversion trigger are transaction conversions. If the company is sold or substantially all of the assets are sold, then seed investors can elect to either be paid the outstanding principal and interest or, more likely, convert their shares into equity, again at a discount, and get paid a portion of the purchase price. So they've bought in at this level, you've grown the business, you're now selling it off to presumably a larger buyer. They're going to convert their note at that time and get it to take in a portion of that purchase. Now, with convertible notes, there's typically a maturity date. So if all else fails, your final conversion is going to be that maturity date, typically about 12 to 24 months that have passed since the note was signed. That'll trigger a conversion where the investors can exercise a couple of different options. They can convert the note into equity based on some predetermined value. They can demand repayment of the note, although companies usually in this position aren't actually in a position to then pay out cash in order to repay seed investors. Or what will often happen, they'll leave the notes outstanding and then wait for another conversion event to trigger. And of course, sometimes, like most things in life, all of this is, of course, negotiable. So sometimes you'll see these investors use this as an opportunity to negotiate an even better, sweeter deal or a larger portion of the pie because you're taking too long. Because a convertible note is a debt, the notes do accrue interest. Typically, I'll see something like 4 to 8%. But instead of paying out the interest in cash, the interest accrues and then converts into additional shares during the next round or when that conversion event happens, which helps to increase the investor slice of the pie. On the other hand, you've probably heard about the simple agreement for future equity or the SAFE, which was pioneered by Y Combinator. And this was created to eliminate the debt baggage that goes with the convertible note. A SAFE is more like an equity linked contract, not really a loan. So it doesn't have a maturity date, it doesn't accrue interest. So by removing the maturity date entirely, a SAFE, in theory, gives you an unlimited amount of time to grow the company and then get to one of those conversion events. And since it's not accruing interest, investors in safes are really limited to either converting the debt into equity if and when we get to one of those conversion events, or getting priority over the other equity holders like you and your co founders and having your debt repaid if things don't work out and the company were to dissolve. So, one of the first key points I want you to take away from this: if you're a high tech growth startup and you've got a clear path to a venture capital round in the next 12 months or so, a safe is typically going to be the default option. But if you're not a tech startup, maybe you're a slower scaling business, you're simply dealing with more traditional angels, maybe even friends and family as the seed investors, and they want more of the protection of a debt instrument. They want to see something accruing interest. Then you might need to prepare for the debt obligations and the repayment pressure of a convertible note. Although I will say that if you're negotiating with less traditional seed investors like friends and family, you might be able to negotiate a longer term on that note and treat it more like a traditional promissory note. So, once we've kind of figured out the maturity window and which of those two documents, the SAFE or the conversion note, is more likely the best for your particular scenario, the next thing we need to start figuring out are the various economic levers that are really going to determine what these investors ultimately get and how large a portion of your company they end up taking. And for this, we're going to look at caps and discounts. So, convertible instruments allow investors to receive equity at a more favorable rate than the later investors in your next equity financing. And the way that we accomplish this is through two primary levers: the valuation cap and the discount rate. Now, the discount rate gives early investors a percentage based discount off of the purchase price that are paid by the later, usually what we call Series A, often venture capital investors. So, for example, if in your Series A round that comes later, those investors come in and they pay $1 per share, and your seed investor has a 20% discount, they would only pay 80 cents per share. With the valuation cap, we put in place a ceiling or a cap on the valuation that's used to convert the seed investor's money into equity. Now, next key point: these aren't just terms, right? This is not just something that the lawyer is throwing out there, or if you found something on the internet, these aren't just random terms that have been thrown around. Think of these more like prices. If you raise your Series A at a $10 million valuation, which congrats to you, but your seed investor has a $5 million cap, what this really means is that they're ultimately going to get twice as many shares as the new money, your Series A investors, those venture capitalists, for the exact same dollar amount. So when you have both a cap and a discount, now you've got a note or a safe that's going to convert at the price that's lower depending on the more favorable of the two. And we're going to look at an example of this a little bit later on. The bigger thing to take away at this point is that the discount rate and the valuation cap lead to what we call deferred dilution. The most dangerous mistake an entrepreneur can make is viewing these instruments as free money, right? Don't walk away from this feeling like, oh, it's a convertible note. If it never converts, I'm fine. No, you've got that maturity date coming. You're going to lose something, either money or a portion of this company. Same thing with the safe. It may not have the maturity date, but eventually that note is going to convert, and those investors are going to get either repaid or they're going to take a portion of the company. So you're ultimately diluting your own ownership stake in the company. That's the price of taking on investors. When you finally complete a next equity financing, you're going to be diluted only by the new capital coming in, but also by the conversion of the outstanding convertible instruments at either their favorable cap or discount rates. So it's not like, hey, by selling these safes or convertible notes, I'm losing X percent of my company today. Yeah, you are, but The whole idea is that there will be another round later where you're going to give new investors an additional portion of the company, and that's going to change those numbers even further. This can be compounded by something called note overhang. So, if you end up doing multiple bridge rounds or multiple rounds of the seed funding using convertible notes and safes, say over a couple of years, before you even get to a priced round like a Series A, typically what will happen is all of those notes or safes will convert at once. And so, founders are often shocked when their personal ownership drops from, say, 80% to 30% in a single day because you've had multiple rounds of convertible notes or safes that are converting, and you've got that successful, right, successful in quotes, Series A that's also further diluting your ownership. So, one of your big action items when you're considering using this to raise some seed funding, check your term sheet. Sometimes they will include something called most favored nation clauses. And these are provisions that require you to give early investors the benefit of any more favorable terms that you offer to investors later. So, when we talk about that note overhang, if you do multiple rounds of convertible notes or safes, a sophisticated angel investor will ask for most favored nation status so that if you go back later and give, say, Dear Uncle Joe a better deal, that angel investor can come in and say, my note needs to convert on those more favorable terms as well. So now that we've looked at all of that, the next thing, and probably the most critical, is to actually drill down into the numbers and model what that conversion will look like. So let's walk through a very simplified hypothetical example, and we'll use what's called a post-money safe, which can make the math a little bit clearer to see exactly how much the initial investor is potentially locking up. So let's say, for example, you have a wealthy Aunt Jane, and she wants to invest in your startup, and she's going to use this post-money safe to do so. And let's say, just for simplicity's sake, that Aunt Jane is going to invest $250,000. So she's going to get a safe agreement that says, in exchange for her $250,000, if certain conversion events happen, she can then convert that into equity. Now, let's say that that safe also uses a valuation cap of $2 million. So that's the agreed cap, and that will effectively lock in Aunt Jane's ownership percentage. Now, we'll fast forward to the future. This is a tech startup. It's growing. Things are going well. You've got a viable product. You've convinced venture capital to take you on. They come in and value the company and they say, hey, we think on a pre money valuation, this company is worth $3 million. For all intents and purposes, that's the valuation that's negotiated or set by those Series A venture capital investors. Now, let's assume, again, just to keep this simple, that you owned all of the shares prior to any of these investments. So we'll just use a round number. 5 million shares is how you set up this company. You had all 5 million of them. We're not going to complicate this right now with options for your for your initial team members, those early employees. We're not going to add a bunch of co-founders or additional investors. Now, the Series A, they valued your company at $3 million, but they come in and say, okay, we're willing to invest $1 million. So that's the amount of capital that you raise in that priced round or that Series A round. So to actually put some kind of math around this and figure out what's going on here, your first step is to figure out how much Aunt Jane is kind of locked in at before those Series A investors come in. And to figure that out, we take her investment, so the $250,000, and we divide it by that valuation cap, the 2 million that she included in her safe, and you'll see that she's locked in at 12.5%. Now, the next step, we want to calculate what her shares look like and what the total number of shares in the company are once Aunt Jane's safe converts. And this is before we factor in the Series A investors. So we're going to deal with Aunt Jane first. So that Series A round has triggered her conversion. At that time, we start figuring out, okay, how many shares does Aunt Jane get because of this conversion? Because her percentage of equity is effectively locked in, we know that if she has 12.5%, your 5 million shares have to represent the remaining 87.5%. So the total shares post-safe will effectively be your 5 million divided by 0.875, about 5.7 million shares. So Aunt Jane ends up with just a little over 700,000 shares, so that her portion represents 12.5%. If you do the math, she's effectively paid 35 cents per share, her $250,000 investment divided by her 700,000 some odd shares. Now we're going to look at the Series A investors and figure out the final ownership piece of this. So we know the Series A price is going to be based on that $3 million value that they negotiated, divided by the 5.7 million shares that are outstanding, or 52.5 cents per share. So if the Series A investors put in $1 million, they're going to receive a million divided by 52.5 cents per share, or just over 1.9 million shares. And so when you look at it, at the end of the day, this is what your cap table will look like after Aunt Jane, her safe, after it converts, after the Series A venture capital comes in. You still have 5 million shares. Aunt Jane now has a little over 700,000. Our Series A investors have just over 1.9 million at a slightly higher price. That'll bring you to a total number of shares of just over 7.6 million. Your 5 million now only represents 65.6% of the company. So one of your big action items anytime you're considering bringing in investors, particularly using one of these instruments, always run a pro forma capitalization table before you sign any term sheet. I've used a simplified example for the purposes of explaining in this video, but there are plenty of examples and templates out there that you can use to model this with significantly more complicated scenarios. If you have co-founders, if you've if you've set up an option pool, you're doing equity incentives for your early staff and employees. The bigger point is that modeling your cap table will allow you to see what happens to your ownership if you hit that valuation target of 2 million that you negotiated with Aunt Jane, if you do better, if you do worse, if the Series A investors come in here versus here, you can kind of play with the numbers and figure out what all of that looks like. And what you'll notice is that if the Series A valuation ends up being less than that valuation cap that you negotiated with Aunt Jane, both your seed investors like Aunt Jane and the Series A investors are going to end up with significantly more shares, and you're going to end up with a significantly smaller stake in your own company. So I know that's a lot of detail and it's a lot of math, but it's important that you work through these concepts and understand what can potentially happen here. But that's not all. There's one more step. The final step in this process is to make sure that you're actually compliant with federal securities laws and what we call state blue sky laws. You see, when you accept money in exchange for a promise of a future return on investment, the instrument itself is considered a security. You have now triggered the need to comply with both federal and state securities laws. Now, the two primary federal securities laws that apply when a business wants to raise money from investors are the Securities Act of 1933 and the Securities Exchange Act of 1934. If your business is selling securities through interstate commerce, meaning across state lines, these federal securities laws apply. Don't try to get funny and say, oh, they're not really investors, they're just business partners or silent partners. The law will see through all of that funny business. If they are providing money in the hopes that you will provide them a return on investment, they are investors no matter what you try to call it. If it looks like a duck and quacks like a duck, it's a duck. So, for example, let's say you have friends from college, they live out of state, you think they might be interested in investing in your business. If there is an exception that those friends, or sorry, an expectation that those friends could potentially earn a return on their investment in your business, then regardless of what you and your friends call it, it's a securities transaction. And because your friends are out of state, your business would be selling securities in interstate commerce, and you must comply with federal securities laws. This means the transaction must either be registered with the Securities and Exchange Commission, making you a public company, or exempt from registration. At the federal level, registering a small seed stage offering with the SEC is impractical, expensive. You're not going to become a publicly traded company. Instead, startups rely on exemptions from registration. And there are a couple of common categories of exemptions: your interstate transactions, what we call private placements, and the relatively new regulation crowdfunding. Now, the offering exemption is exactly what it sounds like. All of your friends from college are here in the same state. We're not selling in interstate commerce. That will exempt you from having to register with the SEC. Again, there's some nitty gritty details, but we're not going to worry about that too much today. More commonly, what we see used are one of the federal private placement exemptions. So, Section 4A2 of the Securities Act exempts from registration transactions by an issuer not involving any public offering. Now, to qualify, investors must either have enough knowledge and experience in finance and business matters to be what we call sophisticated investors, meaning that they are able to evaluate the risk and the merits of investing in your company, or they're able to bear the economic risk of investment. In other words, can they stand to lose it all? They must also have access to the type of information that would normally be provided in a prospectus if this was a registered offering. And that's where we start talking about private placements. And they have to agree not to resell or distribute the securities to the public. After all, this is a private transaction or a private placement. Because these are not public offerings, you're typically not allowed to do general solicitation or advertise for investors. Now, the downside to this private placement exemption is that it doesn't really provide any further guidance regarding how you qualify for the exemption. And for that reason, most businesses actually look to what we call the safe harbor provisions found in Regulation D. And there are three big ones, but the main one that you will see used is Rule 506B. Now, these Regulation D exemptions require a notice filing with the SEC called Form D, and this has to be submitted within 15 days after the first sale of securities in the offering. If at all possible, we usually submit it a little early. This isn't the same as becoming a publicly traded company. You're not going through a full review process. This is just, hey, here's a notification of what I'm doing, how much money I'm trying to raise, what exemption I'm relying on. Now, as I said, Rule 506B is the most common safe harbor for private placements. And put simply, this rule provides specific requirements that, if you follow them, will firmly establish that the transaction falls within the private placement exemption. So, to qualify for the safe harbor, again, no general solicitation or advertising. You cannot sell your securities to more than 35 non accredited investors. You can have as many accredited investors as you would like. If you do have non accredited investors, then you have to provide those specific disclosure documents that we talked about, hence the need for the private placement. And you have to be available to answer questions from prospective investors who are not accredited. The good news is that there's no limit on the amount of money that you can raise under this rule. Now, there's one other kind of newer exemption you might hear about, and that's Rule 506C, and this was implemented by the Jobs Act. This exemption is sometimes used, although it's still rare in my experience, because it allows for general solicitation. So you can actually advertise that you're looking for investors. However, all of the purchasers have to be accredited investors, and you have to take reasonable steps to verify their accredited status, usually with third party verification services. So, again, this is why we don't see this one used nearly as much. So, if you're looking at Regulation D and probably Rule 506B, what makes someone an accredited investor? These are limited to particular qualifications, and there are a number of them, but the most important ones for business clients that I work with So the business's directors, executive officers, general partners, you as the founder, right? You automatically qualify as an accredited investor. You can invest in your own business. Any other entity where all of the equity owners in that entity are accredited investors can also invest in your company. But what makes an individual an accredited investor is they have a net worth of at least $1 million, dollars, not counting the value of their primary residence, or they have an income that's greater than $200,000 in each of the two most recent calendar years. Or if you're looking at it jointly with their spouse, then it's $300,000 for those years, and a reasonable expectation of the same income level in the current year. So those are the primary situations where you're looking at accredited investors. There's also a criteria for trust. So if you know your rich Aunt Jane has most of her money in a trust, if that trust has assets of $5 million, that trust would also be an accredited investor. So how do we figure this out? How do we figure out which investors are accredited and which ones are just sophisticated and would require something akin to that private placement memorandum? Usually, we'll use an investor questionnaire to qualify prospective investors and determine whether they're accredited or merely sophisticated. So, this is going to ask for things like their net worth, their income, that type of information in order to verify which category they fall into. Again, you can have investors who are, merely sophisticated investors and not accredited, but then you are required to provide those disclosures to them. And generally, putting together a private placement memorandum is going to raise your legal fees significantly because there's so many things that go into those disclosures. In light of the anti fraud provisions in securities laws, so I often explain to people that when it comes to complying with securities laws and what you tell your investors, think of it much like law and order, right? You're expected to, when you get up on the stand, you're expected to tell the truth, the whole truth, and nothing but the truth, so help you God. Same thing when you're dealing with investors. You need to tell them the truth, the whole truth, and nothing but the truth, or they can potentially come back and sue you for securities fraud. In light of those provisions, generally, if you have a mix of both accredited and non accredited sophisticated investors, you're going to provide them with the same disclosure information, usually in the form of that private placement memorandum. You're going to give all of the investors the opportunity to ask questions and conduct their due diligence, usually in the form of a conference call or a Zoom meeting with you, your co founder. Sometimes I'll join as legal counsel, and we'll go through all of that, even though it may not technically be required for those accredited investors, just so we don't have the situation where somebody comes back and later and says, oh, they told me X, but they really did Y, or they didn't tell me about A, B, and C. So here's your checklist. Even with a convertible note or a SAFE, you still need to verify investor status. Remember to use that Regulation D exemption, Rule 506B. All of the investors must meet the criteria of an accredited investor, again, typically based on specific income or net worth thresholds, or be a sophisticated investor, meaning they've got the experience to really understand what they're getting into and the financial wherewithal to potentially lose their entire investment. And if any of these investors aren't accredited, so they're merely sophisticated investors, then you need to provide that private placement memorandum that's going to increase your legal expenses, but it's worth it to help minimize the risk that you get sued later for securities fraud. Then you need to prepare that Form D filing, and this is usually done by counsel, but that's the required notice of the exempt offering to the SEC. The final piece of your checklist is going to be checking those Ohio specific blue sky requirements. So, in addition to federal laws, every state, including Ohio, has its own blue sky securities regulations. And you must comply with the state rules in every state where you have investors. Usually, this just means filing a brief notice of the exempt offering with the relevant state agency. So, here in Ohio, when a business is relying on the safe harbor provision of Rule 506B, you would file a copy of Form D with the Ohio Division of Securities within 15 days of the first sale here in Ohio. Now, Ohio, at the time of recording, charges a $100 filing fee. If you think you might have investors in several different states and you're relying on Rule 506 at the federal level, you often end up having to file a notice copy of Form D in each one of those states. I'll briefly mention there's also an exemption from that filing if you have 10 or fewer investors here in Ohio. So that can help to kind of mitigate some of the paperwork and the filings. The big takeaway is that failing to comply with both federal and state securities laws runs the risk of an investor suing you for noncompliance or securities fraud. And when they do that, they can demand a return of their entire investment. Even worse, you and your co founders can be held personally liable for securities fraud, meaning it's not just the company that these investors are going to sue, they're also going to sue you personally, and you personally will be on the hook for returning their money. The biggest mistake at the end of the day is not choosing the wrong instrument. It's not, hey, did you pick the convertible note or the safe? Oh my God, you did one wrong. That's not the issue. It's failing to realize that every dollar you take today is a percentage of your company that you're giving up tomorrow. So if you don't model that cap table, you might very well find yourself losing control of your company and becoming at best a minority owner. If you're looking for investors, chances are you're also offering equity incentives to your early team members and employees. Watch this video on protecting your startup with key person vesting next. And if you're considering a term sheet right now, visit msnlawoffice.com today to schedule a consultation.